Good morning, folks. I'm attorney Roger P. Foley, and driving over to the courthouse today. I have a small matter. Had some other things that were reset this morning, and we'll be tackling those in the near future. But I wanted to just talk to you. I think my general outlook on things lately has been a little bit dim. Lost a trial that didn't think I should have lost, and obviously I understand that that's part of the criminal justice system. You know, I've heard people tell me over and over and over, you can't win them all. I try to have the mentality that I can win them all. So when I recently lost, it was a blow. And I don't mean when I say you can win them all. You know, the thing is as a private defense counsel, you can be selective. You can be selective in the cases that you take. And I've taken a lot of cases where, you know, the clients have come from other attorneys and they were told that, you know, it's got to be a plea bargain. There's no motions to suppress. There's nothing, and we've always figured out a way. But here's a case that I think we should have won. And I'll probably be analyzing it for years, trying to figure out what would have been a better approach. You know, what did I do, or what was it in the facts? You know, because I don't know if it's me as a defense attorney, if I made the mistake, or is it the facts that the jury didn't like? You know, the problem is you never know, because you don't. It's rare that you get to speak to the jurors. Sometimes you do, but apparently after a loss, they run out. They're told by the judge they only have to talk if they want to talk, but they're shuffled out the back door, and you know, unless you know you have spotters out in the hallways to find them, it's you know, it's difficult that you're going to have an opportunity to ask them, hey, what was it that made you come back guilty? Same thing with, you know, when they come back not guilty, you don't always get to see them. Anyway, I think my faith in the system is greatly diminished. You know, I talk to so many different lawyers, and they all have that perspective. Hey, all you can do is do your best, and I understand that. But my goodness, I thought that the good guys, the people who were charged and probably shouldn't have been charged, the people who were filed on and probably should have been filed on, the people that, you know, the deal isn't, you know, the deal that the state offers isn't very good, you know, because they didn't do it, or the facts are so sort of ambiguous that, you know, you really don't know. You always like to say to a client that things always work out in the end. In this case, they didn't. So I've been down on the system, I gotta say, for the last several weeks since the trial. I just don't know. But I've also had to analyze other cases that I have. I just took a depo on Friday on another case, an aggravated assault with a firearm. Normally has a 3-year minimum mandatory, but the governor recently changed that. So I think as of June 1st or July 1st, there's no longer going to be a minimum mandatory. Basically, they're doing away with the 1020 life statute. It appears that way. So they're not going to have minimum mandatory charges on certain gun charges. So that's a good thing, because I think there's a lot of people in prison that, you know, pulled a gun, and they've done so rightfully. You know, the state of Florida, up until the governor's signature, has been really of the attitude of, if you have a gun, you're going to be charged, you're going to be prosecuted, and you're probably going to go to prison. Unfortunately, that's not right, but it looks like they're trying to work on that. The governor signed the paperwork to make sure there's no minimum mandatory. So, but I took this depo. it's rare that I deal with a witness that I just, in my own gut, I go, you know what, there's a real high likelihood that what they're sharing is truthful. And I got that. So now I gotta explain to a client what a jury's gonna see in regards to that individual. And if I think that they come across as fairly credible, not to say that my client's lying, but if they come back as very credible, then their likelihood, the defendant's likelihood of being convicted of the crime dramatically increases, because ultimately the jury's going to ask the question like, well, he seems pretty credible. What do you do in that situation? I don't know. The client will make the decision, but because of the case from 3 weeks ago, I really are, I thought I analyzed things a lot before. That's increased. So just know, folks, that the system's not fair. Just know that if the case goes to trial and you lose, the judge isn't your friend. The judge isn't going to see through it. The judge is no more than a hired gun for the state, and he sentences accordingly. There are a few judges on the bench, and I don't want to name names, but there's a few judges that I know that are pretty fair. But my goodness, folks, it's like my thoughts on police. About 25% of them are good and don't lie, and the rest of them, they're not worth the what. That's my impression of judges these days. That they get caught up with they get caught up. They do deal with a lot of bad folks, and those folks that have committed crime after crime after crime and just keep getting arrested, right? You can't really, it makes it a lot more difficult to argue that they're innocent. But the guy that has one charge and you sentence him to prison, and it's not even like a serious matter, what other reason do you have to do that other than, you've become desensitized to your own sentencing practices? That's how I feel. All I can do is do my best in the system. And I found that in this recent last case that doing my best didn't work. So I'm a little negative Nelly right now. Obviously each case I'm going to start over and go for broke. I got another trial coming up in I think in a few weeks. It's going to be reset this morning, and we'll know. And it's a tough case. It's a case that I've had to share with my client that, hey man, the odds aren't too good against you, but apparently the client is very sincere that he was innocent, that the officer charged him when he shouldn't have, and we have a new witness in the case that's gonna give us some surprising testimony, which, if believed, is very credible. But if I can punch holes in it and why the delay in getting that information, then my client's got a decent shot. It's going to be a tough one. I'm going to have to refocus, rejuvenate, and get ready for another battle. So I'm attorney Roger P. Foley. Guys, just be careful before you set your case for trial. Make sure you have the highest chances possible of winning it. It's always a gamble, but have your attorney do everything he can. Ask every question you can, because the last thing you want to do is end up on the losing side, which is 95% incarceration. I'm attorney Roger P. Foley, just blabbering on the way to the courthouse.